So hello and welcome to today's webinar, Assessment Collections at Your Community During the Coronavirus Crisis. My name is Russell Munns and I'm the founder and president of Community Financials, a national provider of monthly accounting services to HOAs and condos. Collections at Your Community During the Coronavirus Crisis is a one-hour webinar designed to help boards, managers, and accounting staff responsibly manage collections during the pandemic. A few months ago, collections were simple. The economy seemed to be growing. Unemployment was at historical lows, and then just a few weeks ago, the economy was shut down, and now economists are discussing a recession worse than 2008. And later this week, tomorrow, the stats come out from Bureau of Labor that we're likely to see unemployment claims reach 30 million workers, which is 3 times more than what we saw in 2008. To help provide direction, we've brought 3 experts together. Attorney Douglas Levy, Counsel for the Community Association Practice Group at Rees Broome in Tysons Corner, Virginia. Mitchell Drimmer, a licensed Community Association Manager and President at Axela Technologies, a national collection agency specializing in condo and HOA collections, as well as myself. We're first going to discuss common questions about collections during COVID-19 that all 3 of us have received over the last few weeks. And then later we'll answer questions from you, the audience. Due to hundreds of people attending today, everyone's been muted, but you can ask questions at any time by typing your question into the question box in the control panel at the bottom of your screen. We'll be answering your questions during the last 20 to 30 minutes of the broadcast, so type your questions and we'll get to as many as time allows. I hope you're ready to take notes, but like all of our webinars, we're recording this session, so it'll be available on our YouTube channel and at communityfinancials.com for future playback. Now it's time to introduce our speakers. Douglas Levy has been practicing law since 2002 and has focused on community association law since 2008. He's handled assessment collection matters for condominium and homeowner associations in Virginia, Maryland, and the District of Columbia. And he's well-versed in the challenges involved in the world of assessment collection. He has spoken about collections often for educational classes and seminars and has authored articles on the topic, including Quorum Magazine, published by Washington Metropolitan Chapter of Community Associations Institute. Mitch Drimmer has been in the trenches of HOA and Condo Collections since 2007 and has experienced the ravages of severe economic slowdown. As a licensed community association manager and accredited by the ACA for collections, Mitch is well positioned to help associations through what will be hard economic times. He has led numerous continuing education classes in collections. His articles have been published in key trade journals, newspapers, and he's a speaker at educational seminars. As for myself, I've been in the community association industry since 2001, first as a manager and then as an owner of a full service management company. I then started this firm, Community Financials, to be the backbone of strong and cost-effective financial management services on a national scale to communities and their managers. I'm a certified manager of community associations, a licensed community association manager in Colorado, Connecticut, Virginia, Georgia, Florida, and Illinois. And I've written dozens of articles for CAI, and I've been a speaker at CAI educational events. And I want to start off by thanking all of the attendees today for joining us. So there are a lot of challenges you'll face handling the finances of an association, especially in challenging times like we're living in now. First and foremost, correctly and consistently handling delinquencies that are likely to soon grow significantly. And this collection shortfall will create a cash flow issue that impacts your ability to pay bills and retain vendors. But perhaps you're not on the board or working as a manager or accountant during the last recession. So today is a great place to learn how to better handle the changes that may impact your community in the days and months to come. To start off our panelist discussion, and since all 3 of us luckily have survived and lived through the last recession in this industry, I want to ask Mitch and Douglas, how does this crisis compare to 2008, the Great Recession, and real estate meltdown, and how is it different? And up first, I'll ask Mitch.
Okay, well, the 2008 recession was caused by the real estate industry. You had banks giving out mortgages like they were Pez candies. You had very flimsy underwriting. It was caused by greed on behalf of the banks, and you had a lot of speculators who were buying and flipping homes in condos and HOAs, especially. And you had people who wound up with homes that were underwater, and they would stop paying. They stopped paying the banks, they stopped paying the associations. So the cause of the economic crisis was real estate driven. It was the real estate market that crashed and brought down everything else. The difference today is that this is caused by what they would call an act of God, by this insidious virus, which has really affected the economy by putting people out of work. Hopefully it's temporary and we'll come out of it soon, but it will linger. And hopefully we're going to see that people will be defaulting on their, we're going to see people defaulting on their assessments, just as we did in 2008. That's well, that's how it's the same. That's not how it's different. Doug,
yeah.
How's it?
So yeah, I think all of those points are exactly right. In the prior recession, one of the things that was happening was people were just giving up on their properties because they were just so far through. And as Mitch noted, one of the key differences today is that at least right now, properties, people impacted by the pandemic and the financial crisis, hopefully still have equity in them. There's, at least right now, if your property had equity in it before everything kind of got bad in early March, mid-March, I think there's somewhat of a belief that equity hopefully still be there today. At least there's no evidence yet that the real estate market has taken a hit on a national scale. And I think that's in part because things have happened so quickly in 6-7 weeks that we haven't seen that. And hopefully we don't see that happen where there's a decline in equity or value. If those homes do retain that equity, I think that's going to make a big difference in weathering this storm financially for a lot of people. Another difference, I think, is that back in 2008, when people were buying those properties and taking questionable loans, I think to some extent they knew that there was risk in what they were doing, that there was a chance things could come crashing down. I think there's somewhat of a belief today that hopefully there were some lessons learned from when that bubble burst back in 2008, and that people hopefully have been making smarter purchases with their homes and not biting off more than they can chew. If they have done that and they've taken what I'll call smarter loans, that's going to help as well going forward. I think when the meltdown in 2008. I think that meltdown was somewhat more gradual, certainly, than what we're seeing today. I kind of liken it to watching the waves at the beach. Sometimes you can sit there on the shore and watch, a wave that's way out there start rolling in and eventually comes crashing down. That was sort of the case back in 2008. It was, you could see it coming. But other times, by contrast, today, you're in the water and you turn around and a wave just smacks you in the face out of nowhere. That's kind of like what we're going through now, just to make an analogy. So it's kind of like I think at the end of the day, we never really saw this coming. But hopefully the short-term impact, isn't as, harmful as it was back in 2008.
Time will tell.
It definitely was a tsunami.
So how is this the same as what we went through in 2008?
Well, the same is this. No matter what the reason for people not paying assessments, and I believe there will be a spike in delinquencies as far as community associations are concerned, and the maintenance fees that people have to pay, or if you want to call them common dues or whatever. it doesn't make the difference is that the associations need money. You're running a $0 business here, in that what you budget to spend is what you budget to collect, and people's community association maintenance fees, dues cover the budget, very specific. So, you know, whether it's because of an economic crisis due to the real estate meltdown, or an economic crisis due to a terrible virus like this, the fact is that the money is not going to be coming into the associations, and that's going to hurt the associations, and they're going to need money, and they're going to need to collect money to keep the association moving and working like the business it is. And please, nobody make any mistake. A community association is a business, and there's a revenue stream, and there's an expense stream. The only difference here is that in a community association, it's a not-for-profit in most cases. I know very few that are for-profit. And if you budget $100,000, you better receive $100,000, or there's going to be special assessments, increase in dues, or reduction in services. Doug?
Yeah, I agree. I think the role and the responsibility of community associations today is the same as it was in the prior recession. Community associations have a responsibility to try to get the amount of income they collect as close as possible to the amount of expenses. And those associations really only have one source of revenue stream, and that's assessments or maintenance fees, as they're called in certain parts of the country. So that was true 2008. It's true today. But you know, one thing that's also the same as I think we're starting to see is that just as the case was 12 years ago, community associations are quite vulnerable to seismic shifts in the economy.
Yeah, great. All right, next up is, what do both of you estimate the delinquency rates will be over the next 4 quarters?
Yes, well, you know, I've spoken to all the accounting and the experts in my business. They do algorithms and predictions. I've even gotten one of these, okay? And you got to laugh sometime. I'm stuck in this house for 7 weeks. I got to come up with the joke somewhere, folks. I'm sorry. It's my crystal ball here. I'm thinking that we may be hit with anywhere from 20 to 30% delinquencies for the 3rd and 4th quarter. Going forward beyond that, because people are out of work now. A lot of people are out of work. And remember, 25% of Americans live in community associations, according to CAI. So if you extrapolate how many people are unemployed now, what's the unemployment number?
It's going to be 30. It's going to be 30 million this week. End of this week.
30 million people are out of work. 7.5 million, that means, are people who live in community associations. If you want to, you know, extrapolate it. So I'm looking at 20 to 30% for this quarter, and then when people gets back to work, hopefully it improves. But remember, we're living in a world not like my parents' world, where daddy worked and mom stayed at home. You have 2-income houses, so you may even have a situation where one wage earner goes back to work and the other one doesn't, and then the family has to make difficult choices. I really think that we will not see a meaningful recovery until next year, maybe the second half of next year. And, you know, I'm hoping that the properties don't take a hit. The price in the properties, the value of the properties don't take a hit like they did in 2008. I'm really hoping for that. And I don't think that they will. I think that the equity that people have in the home prices and the condo prices will not be dropping 20, 30, 40, 50%. but we will have delinquencies, and we will have substantial delinquencies that will affect the operations of a community association. Douglas?
Yeah, I think because we're still so early in this process, it's very difficult to predict. What's interesting is for a lot of community associations, when an account becomes delinquent, when it actually gets turned over for collection, it's usually around the 90-day mark of that delinquency. And we're still less than 2 months into this crisis. So we haven't quite seen that anticipated flood of delinquencies just yet, but it's potentially coming. If somebody's ability to pay has been impacted specifically because of the current crisis, if they lost a job or the main wage earner in the house lost their job, that account quite possibly has not yet been turned over. Like Mitch, if you look at the numbers, they're pretty staggering when you extrapolate them to how that might impact community associations. And in some areas are harder hit than others. And it wouldn't surprise me if in some of those hardest hit areas, the delinquency rates spike to 20 to 30%. That's quite possible. I don't think those levels will be across the board. At least I certainly hope they won't be. Some geographic areas are better positioned than others to withstand the crisis, or at least weather it better than others, especially if they have local industries that remain in high demand. So I guess that's a long way of saying that it's still a little bit too early to tell at this point, but I think, like Mitch said, that wave is coming.
I think,
and I don't think that it's a little rough to say that of the fatalities we've had, is 60,000, 15,000 of them, if we go according to, who owns condos and HOA, 15,000 HOA and condo owners, community association owners have passed. It's going to be a lot of action in a probate court.
Typically what we see as far as delinquencies, depending on, it's are 2 to 7% as the norm. And so, yes, the spike could go much higher as it did in 2008. And, realtors are talking about a small level of adjustment in housing prices of maybe 10 to 15%, but we'll see if any of our crystal balls are correct. It all depends on a community by community basis and what the demographics of that community are, because some communities might not be affected at all. All right, our next question is it the responsibility of the board to care and watch over its members? And Mitch, what do you have to say?
Okay, well, I have to deal with this issue a lot being in the collections business. And the answer is that a board of directors member was hired to be a fiduciary of the association. They're there to care for the association, and their focus should be on the association. Now, as cold-hearted as that may seem, there's nothing that they really, any business of theirs, to help people with their own personal problems. Now, that doesn't mean that they shouldn't have a heart, but when a meeting is convened until it's adjourned, the focus should be on the health of the community, not on the individuals. They're not responsible for the individuals. And if they do want to be good Samaritans, we'll start a GoFundMe page or get collections or get a drive to help people out in the association if they want to pay for them. I mean, I've been to meetings at boards of directors where the board of directors was yelling at me, was interviewing me to do collections, and some people got very disturbed about, collections. And I always ask, if you're disturbed, raise your hand. And I said, if you're disturbed about it, then why don't you take that hand and write a check? Because that's whose pocket it's going to come out of. So it sounds cold and it sounds harsh, but no, board members are not responsible to be the
Watch over
parent.
its members. All right,
Yeah.
Douglas, what do you have to say?
Yeah, I agree. I think the board's primary responsibilities are for the preservation and the protection of the property within the community. And of course, to protect the financial health of the association as a whole. They're not there to protect the financial health of a particular member, rather the entity, the association, the community at large.
Yeah.
And of course, a board can and should try to be compassionate and be understanding of the problems that members are facing. But at the end of the day, it still has to put the financial interests of the association ahead of the financial interests of any particular member.
All right, and then we're going to try and speed things up a little bit. We've got a lot to cover here. So here's one of our main questions. Can a board waive collecting assessments?
Okay, I'm speaking, my disclaimers, I'm not an attorney, but I have never seen governing documents that contemplate giving the board of directors the power to waive off collections of assessments. Au contraire, that would be a failure in their fiduciary duties. And I've never seen it. And I don't think that they have the right to do it. And I'm going to move this on to Douglas to answer.
Yeah, the short answer is no. They cannot waive collecting assessments. A board of directors derives its powers and its responsibilities from the community association's governing documents and the applicable law. And those governing documents mandate the collection of assessments. They don't give the board discretion to decide whether or not to collect them. So to the extent that there is any discretion that a board might have, you may see that in areas other than the assessments. You may see it in things like late fees or interest, where they might have discretion to waive that if they feel like that's a situation that's warranted to do that. But as far as what I'll call the regular assessments, the annual assessments, no, they can't collecting those.
What are some immediate steps the board should take at this time?
Okay, I've got some answers for that one. First thing to do is call a board meeting together, properly notice a board meeting, and review your uniform collection policy if you have one. If you don't have one, establish one. That'll give you what directions, what you're going to do to make sure that it's fair for everybody. So the first thing you need to do is put together a collection policy on how you're going to move forward. Are you going to go out and send your delinquencies to an attorney to foreclose, or to a collection agency to try and work with the owners and collect on payment plans and stuff like that? The next thing that I think people have to do is you got to establish a fact pattern. First of all, I would think everybody in the association should, the management of the association should put together a list of who holds all the mortgages, who holds what, and then have an understanding of what they're looking at. Get as much information as possible. Another thing I think that there should be done, it's budget season again. Call in notice another meeting. I'm not saying to redo the budget, but go over your budget, see where you could cut some fat, reduce spending where you can without getting involved with life safety issues, and move forward with your collections. Doug?
Yeah, I would also add that one of the first things a board should do is find out if there are any emergency or short-term laws that are recently passed or being considered in their jurisdiction that might impact the collection of assessments. I know we're all being inundated with news these days, and some of the top financial stories tend to focus on Americans' ability to pay rent or pay the mortgage. But there are jurisdictions that have passed laws that put a moratorium on debt collection. One example is the District of Columbia. So if your association has counsel, I recommend you check and see if there's anything that's been passed or might be passed that could impact your ability to collect. And if there is such a law, who does it impact? Does it impact a third-party debt collector, or such as a law firm? Does it impact the association? Well, that answer is going to depend on the specific law. And if a board has reason to be concerned about the payment of assessments within their community, another thing they should be doing, I think Mitch alluded to this, is starting to look into whether there are current or pending financial commitments of the association that they can perhaps put off. Is there a capital improvement project that's on the to-do list for 2020 that perhaps wait a bit? Obviously, some projects are more important than others, but now's a good time to take a look and see if there's reasonable cost savings in the short term that can be taken until the board has a better sense of how its bottom line is going to be impacted, because we just don't know that yet because we're only less than 2 months into office. And just to reiterate a very important point that Mitch made, now is the time for a board to make sure they have a current and well thought out assessment collection policy that lays out the procedures that the board's going to follow in case, so that no owner is treated any differently than another from a due process or procedural standpoint. And of course, that policy should clear, though, that every case is going to be considered on its own merits. And I should also mention that even if you have a collection policy, some of those may be old or outdated. So now, again, take a look and see if updating needs to be done. Do that now before the anticipated flood of delinquencies starts to come about.
I agree. And, I've seen some where the late fees are, $5 or $10 because the documents were written back in, the late 80s or something like that. Right. And that's not a real deterrent for people. And there's a lot of tools to also use as far as, reporting to collection rating agencies and things like that to help, put a stick behind the collection policy. We've got a sample collection policy owners can take attendees can take a look at on the resources page of our website. What relief can the board offer impacted owners? Mitch?
Okay. Well, I think that the very first thing that the board of directors needs to do is make sure that there's an open line of communications. A great president of the United States once said that the only thing we have to fear is fear itself. So let's take the fear out of people's hearts. Let's put them at ease. Let them know that the board is there to cooperate and to help and to work with them and to have somebody to speak to them. Now, when I say somebody to speak to them, hopefully management companies will add on some call centers, or in my case, if somebody goes into collections, we have people to speak to who are specially trained and, have somebody to talk to. But an important thing is that there will be a call and a need for payment plans. So the boards of directors, I've had some boards of directors tell me we don't do payment plans, which really doesn't make my job any easier. But when I'm allowed to give people payment plans, they get on the payment plans, and there's very little recidivism. There's very little people falling off the wagon. So help them ease their minds, open up the communications, and let them know that payment plans will be available to fit their family economies. Douglas?
Yeah, I think a payment plan is certainly a compassionate and a reasonable step that board can take. I agree. Communication is key here. People are anxious, they're nervous, they're scared, especially if they've lost their job or they think they might lose their job in the near future. So I think it's important for the association to be a little bit proactive here and just let people know that if they're experiencing financial hardship, come talk to the board. Let us know what's going on, submit a proposal. Let's see if we can work something out that will help you as the owner and also still help the association by allowing that income stream, those assessments, to be paid. And I'll mention, I've seen some associations proactively waive late fees for a specific period of time. I've seen some do it for March and April, sometimes May, just sort of depending. In some cases, that was a little bit more of an administrative decision, because that it was easier to do that proactively than to handle dozens and dozens of late fee waiver requests. But it's if your association does that, again, if you're willing to waive late fees, I would be very cautious in how often or to what extent you do that, for what period of time. Of course, on the flip side, some associations be willing to waive late fees, just not proactively as an across-the-board policy, but more in the event that if an owner asks for it, then pretty accommodating of that type of request. And lastly, with the payment plans, you have to, this can vary by jurisdiction, but promissory notes, if they're allowed in your jurisdiction, that can be one way of securing the payment plan. So in some places, you can enter to the payment plan and then put those terms of that payment plan into a promissory note to help secure the association's interests.
Great. All right. Now, how can you work out a solution with a person who really and truly does not have the means to pay?
Well, that's a hard question, and it's a hard question with a very hard answer. And the answer is, if somebody can't pay, they can't stay. If you cannot pay, if you cannot no longer afford to live in a community association, if your family economy or your personal finances don't permit you to stay, then you have to make other arrangements, and that's on an individual by individual basis. I think that the best thing for a board of directors and management to advise is, don't let people linger. Don't let these delinquencies linger, because if you linger, people are going to get in deeper holes. And when they sell their property, depending on the state statute, if they have joint and several liability, if there is any equity left in their property, they're going to lose it. And they're not going to, if they have $20,000, $30,000, $40,000, $50,000 worth of equity, I think that the move right now would be to sell your property, and to sell it, and to take out the equity that's in it. And it's a horrible thing to lose a home or lose a house, but just like any other thing, sometimes you got to hunker down, buckle down, and downsize. Doug?
Yeah, those are always the toughest situations to deal with. I always tell boards that if they can't afford to pay you, you can assume pretty safely that they can't afford to pay a whole bunch of other bills as well. You certainly want to do what you can to try to get something worked out. If you can't, you also don't want to find yourself in a situation where you're throwing good money after bad. What I would say, though, is if somebody does not have the means to pay personally, but you believe that there might be some equity in that property, recording a lien against the property might be the step you take to secure the association's interests. In some cases, that's the better way to go. If a monetary judgment's not going to amount to much, the lien might very well be the better option there. That lien provides protection in the event that the property is sold, particularly if there's equity. And it also protects the association in the event that the owner files for bankruptcy, which unfortunately is something that we're probably going to be seeing a lot more of it in that question. If somebody doesn't have the means to pay, bankruptcy, unfortunately, might very well be where they end up going. So getting a lien on the property at least gives the association a fighting chance of having their interest secured.
So as we all know, the association has to enforce collection policies uniformly across the board. And so part of this is coming up with a info sheet or some documentation that you need in order to collect from owners who are, facing these difficulties, maybe not that they need to sell their house, but what do you need, what are we seeing that are being recommended as far as documentation for an owner to provide in order for them to, get some sort of relief from the board and for the board to make a decision?
Well, if somebody can't afford to pay right now, and let's say in 2 or 3 months or a little while along the line, they're going to be entitled to an inheritance or a Social Security or a pension. If they wish, they could approach the board of directors and say, "Hey, guys, I can't take care of it now, but come this time, June 1st, I'm going to be collecting Social Security, or I'm going to get an inheritance, or I've got a new job." So perhaps they could show the board that they will have, financial wherewithal to cover their obligations. It's really not the board's business, but if they're looking for some of the help from the board of directors and want to take that route, then I think that they.
So that's
they
one
should.
thing. That's one thing you can look for.
Okay.
Doug, what else?
Yeah, it's a fine line here, because you don't want to overreach, but yet you do have a responsibility to the association as a fiduciary to make sure that you're doing what you need to verify whatever you're being told by the owner. I don't think it's necessarily out of line. They've said that they've lost their job to ask something that might confront. Again, you don't want to go too far in that, but you don't want to pry. And then, like Mitch said, if they've got some prospect or a job offer down the road that they think is going to get them out of the hole and allow them to start making payments or resume their payments to the association, again, I don't think it's necessarily out of line to ask for some documentation to back that up. But again, you just don't overstep.
Okay. Next is, are delaying collection activities appropriate while not impacting the ability to collect?
Do you mean delaying collection activities by the board of directors? In other words, not moving forward with collections?
All right. Well, so if somebody, I'm seeing where, owners who are impacted by this crisis, the board is delaying collection activities for just those people that are delinquencies that are due to this.
Well, first of all, selective enforcement is something that I talk about a lot. So if the board has 10 people who are delinquent and have gone delinquent at the same time and need to send them to, after they've sent their courtesy letters out, because the process usually is a delinquency occurs, management sends a courtesy letter, then maybe another courtesy letter, and then they either send it to a collection agency to try and resolve it, or to an attorney to lien and possibly foreclose. Delaying tactics, delaying collection activity is not good. It's not a good idea at all, because you're not doing the association a service, and you're doing a disservice to the delinquent owner. If a delinquent owner sees that nothing's happening, they're going to continue not to pay, and they're going to just dig themselves a hole that's deeper and deeper and deeper, and they'll never come out of it. And the association will suffer as well. And remember, it's actuarially unfair when somebody doesn't pay in a community association. So I think that the answer is delaying collections delayed or collections denied. Douglas?
Yeah, I agree. Deferring collection activity is not a good business practice for an association. The truth is that if somebody isn't paying, they're going to continue to not pay until you remind them and tell them that they need to. And the earlier you do that, the better that is for the association. So putting it off, especially when it might be on a large scale, wouldn't be something I recommend. The other thing to keep in mind is, from a legal perspective, is that there are statutes of limitations that apply to the collection of these assessments. Of course, what those statutes of limitations are vary from jurisdiction to jurisdiction, but you have to keep your eye on that going forward, because some jurisdictions are much shorter in the time frame that for when you need to take action by versus others. So that statute of limitations at some point may force you to take action, whether it's a lien or a lawsuit.
So Douglas, as an example, some state has a super priority lien of 6 months. So if it already takes you a couple of months to get your collection policy rolling, and you're out by the time you get resolution on this, you're out at 12 months, and maybe you could only collect 6 months, the board's losing 6 months. Is that right?
Correct. And in some jurisdictions, when you record a lien, there's a limitation to how far back you can reach when you're specifying what assessments are unpaid. It might be 90 days, it might be 6 months. Again, it just depends on where you live. Okay. So what you can actually secure in that lien is going to be impacted by the law. So
and delaying further inhibits that, obviously.
Right.
Correct.
But the super liens that we're speaking of, or the safe harbor or that we have in Florida, we have it's not a super lien in Florida, it's safe harbor provisions, is the lesser of 12 months or 12 months assessments or 1% of the first mortgage. That only comes into play when the bank forecloses. And so there may be people who will be paying the banks and not the associations. I've seen that happen a lot. And one more thing I do want to say about delaying. You start delaying, and we're all hearing about contagious and transmission. If you let somebody get away with not paying, that's a virus unto itself. That will be contagious. The guy next door hears that nothing happens if you don't pay. Why should I pay? These are hard times. And so instead of people struggling and scraping to keep their association together, they say, well, I'll pay my Visa card and other bills. So no, delaying tactics, collections delayed, not good.
All right. So next up, what should boards and management companies do to help their community associations prepare for an inevitable shortfall?
Well, I touched upon this earlier. I said, have a good look at the budget, trim the fat. Any big capital expenditures that are cosmetic in nature, such as, fixing up the clubhouse or redoing the lobby in the condo, stop, put a pause on that right away. If you've purchased any equipment that's not necessary, sorry for healthy people. You can see I don't do much gym, but gym equipment, cancel that order or delay that order, or get on a payment plan with the gym company, and just trim the budget and be careful with your money. This is a business. Downsize.
Right.
Okay, Doug.
Yeah. All excellent points. You got to, I think, as a board, roll up your sleeves and take a look and see, what expenses do we have now that are coming up that we can put off for another day. And going back to an earlier one, I think you want to be ahead of the game and making sure that your collection policy is ready to go for when this, sort of flood of delinquencies that's anticipated starts coming in. I mentioned before, some policies are very much outdated, from the 80s or the 90s. Laws have changed since then. I've seen some policies that haven't changed in 20 years. And there's things in that policy that if they followed it, they would actually be, non-compliant with the law. So you do that now. Take a good look at your policy and make sure that if you need to dust it off and revamp it, do so now.
All right. And also some additional things for cash management. If you've got large expenses, some, insurance, is a big one that usually comes around annually. You could, maybe it's worthwhile for you to pay a payment plan for that. You might pay the interest, but it spreads out your payments over time. You can do that with other big bills. Take a look at that. You can, if you're doing annual assessments or quarterly assessments, maybe switching to monthly assessments so that you can collect money and increase your cash flow. That could be something that you can do. We're also seeing where, owners are asked if they have the means to prepay their assessments to the association so that, they're helping offset, the cash flow that they're not getting from people that haven't paid. So that's another tactic that you can use. Make sure you're using notices properly, courtesy reminders of people to pay late, late notices, et cetera, and following your collection policy like we talked about, but that helps chase the money in. The other thing is offer people a lot of different ways to pay. So if you're just offering people to pay by check, maybe you can offer to make online payments if it's more convenient. I've seen where communities have asked me, we've got owners that live overseas, how can we make it easier for them to pay? So you can, online payments are one way. Another way is offer the option for owners to pay by credit card. So that's a way for them to make their assessments and stay out of the collection policy and for the association to get their cash. So those are a couple of different techniques as well.
Right. I have one more suggestion. I think right now, next week, if you can, contact your association bank. Get yourself a line of credit. Before these delinquencies really slam the association and you become unlendable, put in for a line of credit right now. See if your bank will cooperate and work with you and get a line of credit. And when you need it, use it. If you don't need it, well, I think there's a small charge for it, but it's worth the security. Next.
Yeah. And just to add one other thing, I would try to increase the communication out to the community. Some boards meet monthly, some boards meet quarterly, but nothing says you can't meet more frequently than that. And even if it's just a town hall style meeting that you do telephonically or some other electronic means, people are home a lot more today. Maybe take advantage of that and just have more frequent sort of town hall style meetings just to talk to the community and hear back from them, because you'll get a better sense of where things are going the more you get feedback and input from your members. So if you can increase that communication anyway, I would do that. And
you can do that via web tools also. All right. Yeah. We're gonna use this as the last sort of scheduled question, and then we're going to skip into some panelist questions. Can't the board just take money from reserves to cover the cash shortfall? Mitch?
Oh, I am so against that. Your reserves, first of all, a lot of associations are tremendously under-reserved. They don't have adequate reserves in the first place. But dipping into the reserves, and I'm going to let Douglas speak to the legality of dipping into the reserves, is probably the worst idea that there is. The reserves are there for a purpose. We're coming into hurricane season right now in Florida. You get a roof blown off and the insurance company wants to pay and you don't have the deductible in your reserves, you're in big trouble. The reserves are there for a purpose. The reserves should not be touched unless it's tremendously dire circumstances. And I'm going to defer now to Doug to tell you the legalities about dipping into reserves, because sometimes you just can't. It's not your piggy bank.
Right.
It's not for you to dip in and put into your operating account. Doug, can you pontificate on this a little bit?
Yeah, absolutely. This is one of those questions that is highly dependent on what your specific association's legal documents say. What a board can or cannot do with its reserve funds depends on the language that's in those governing documents. For example, if the governing documents require or allow for an operational reserve fund, that certainly makes it a little bit easier to use those operational reserves to cover a shortfall. But some governing documents are very restrictive, very specific in the language they use as to what those reserve funds can be used for, such as capital improvements, and they don't allow any wiggle room sometimes for anything other than capital improvements. So don't make any assumptions. Even if historically treated your reserve funds a certain way, you've always done it this way for years, go back and check. Make sure you're doing it in compliance with your governing documents so you don't find yourselves in hot water as a board.
Great. One last thing I'll add. The owner of Association Reserves, who did a webinar with a couple weeks back, he had mentioned that a board could suspend transferring money or reserve contributions for several months during this crisis. So let's say for the next 6 months, you don't transfer money to reserves for that period of time. If you've got a reserve plan that goes out 20 years and you're funding a reserve plan for 20 years, that's going to be insignificant for 6 months, and you'll be able to help with cash flow for the community. So that's one way you can kind of a technique that you might be able to do depending on your documents.
Well, let me get this clear. In other words, you're saying that if you've budgeted for reserves and somebody pays, and you're budgeted to put X amount of reserves into the reserve account, you could, before you put it into the reserve account, you can't pull it out once it's in, or you shouldn't pull it out.
This is going on a go-forward basis. You're making new contributions. Typically it's a transfer from the operating account to the reserve account on a monthly basis. And it's in your budget, yes. But if you can, you could redo your budget because your cash flow, like we talked about, and you're making changes. This is one adjustment that you might want to look into.
Yeah, well, there's commingling issues there. So I do suggest you speak to your association attorney.
Yeah. And also just to add to that too, if you obviously want to make sure that that's permissible in your governing documents, but also if you're a condominium that is or wants to continue to be eligible for FHA-backed loans, there are certain reserve funding requirements that go into that approval process, and you don't want to do something that might jeopardize your condominium being eligible for those loans.
All good points and things for people to think about and discuss with their HOA counsel. All right, so I have a question from Anne-Marie Drake. She's an association controller. Are other HOAs waiving or deferring finance charges during this emergency period? And she means by waiving means not charging or forgiving completely all finance charges for a certain period. And deferring means that after the governor's mandated emergency period is over, if assessments are still not paid, then finance charges will be assessed at the normal rate on all unpaid balances back to the last time they were charged.
Well, I think that late fees and late interest are so insignificant that it really doesn't make a difference. It's not going to save the association. It's not going to help anybody. I mean, if your maintenance fees are $400 a month, and they're going to waive off $25 and 1% interest, if it's 12% annual, where's the help in that? How does that help anybody? However, if you use a little carrot and stick mentality and say, I'll tell you what, we won't, our grace period, it's due on the 1st, it's late after the 10th, we have a 10-day grace period. If you pay by the end of the month, by the 30th or the 31st of the month, we won't charge you those late fees. Now you've got a solution. Now you have a good reason to waive off the late fees. Give it a stick to that carrot. Doug?
Yeah, excellent example there of something that the association can do to help owners in terms of extending that grace period. I think I mentioned before, some associations do what I'll call like an across-the-board waiver of late fees for a particular period of time, March, April. And at the same time, I've seen a lot of associations, if somebody asks for a waiver of a late fee or interest, they've been very, very accommodating. I generally think that it's better to, instead of doing an across-the-board waiver, be willing to do so if somebody asks for it, but you certainly don't want to, when you do it as a across-the-board waiver, you risk people taking advantage of that, people not paying when they otherwise can. So you certainly, I would say to answer the question, yeah, I think there's been a lot of accommodation by boards that I've seen in terms of being forgiving for late fees and interest.
Next question from Ray Mulhern, president of a condo in North Carolina. Would you address what we see as 3 separate categories of receivables to determine how collection efforts might differ? I know North Carolina statutes only allow us to lien on assessments, regular dues, and special assessments. But what advice do you have for us regarding collection efforts on other receivables? So 1 is regular dues, 2 is special assessments, 3 are fines and expenses passed to owners where association completed repairs to an owner or were obligated to complete but failed to do so.
Okay. As far as assessments are concerned, in many states, only assessments, maintenance fees, are lienable. And when you go to court, like again in Florida, late interest is lienable, but late fees are not. Okay? Fines and violations may not be lienable in states. But if you're going to go to court and foreclose on somebody, if the association is going to foreclose on somebody, well, all you have to do is foreclose on the assessments, and then you could get title to the unit. But that doesn't mean that the fines and violations and other expenses that are on somebody's ledger are not collectible. Again, as a collection agency, when I'm given a ledger, I'm out to collect everything. And then there's also it depends on your state statutes and your governing documents regarding the application of payments. Some states say late interest, late fees. This is the hierarchy: late interest, late fees, administrative costs, attorney fees, and then assessments. In other states, we have an office in California. My guy tells me there it's Davis Sterling. It's the complete opposite. It's assessments and then work its way back to late fees. So the thing is everything's collectible. If there's a sale on the unit, for instance, and they have joint and several liability, the buyer's got to pay for everything. Got to pay for all the fines, all the violations, everything that's on the ledger. Again, try to collect everything, and if you have to foreclose, well, foreclose on what you're allowed to lien on. Doug?
Yeah, I would say that generally certain items on that ledger are going to be easier to collect than others, just based on the law of that jurisdiction. Assessments, special assessments. For something that I think there was like that third category there of, fines or expenses that the association incurred because they did something, the owner was required to do it and they had to step in and incur that expense and then charge it, pass that cost through to the owner. Those are always a little bit more difficult of a category to collect. Perhaps, if at some point down the road the association ends up having to sue the owner, seeking a monetary judgment for unpaid assessments or special assessments, it may be a good idea if they can to include that third category of costs in the body of that lawsuit. Also, to the extent that those types of fines or expenses are on the ledger, unpaid balance, if you happen as an association to be talking about a payment plan with that owner to get everything paid, perhaps you make sure and specify in that payment plan that those costs are going to be paid as part of it. And, depending on what's allowed under your documents or under the laws of the jurisdiction where you are. Perhaps you can even apply payments first to that category if that's allowed.
All right, great. I got another question here from Gregor Nilsson. If someone in the association is already delinquent before the crisis and in legal, has anything changed after COVID-19?
No, you're delinquent and you can continue to be delinquent. No, you've got to be dealt with. You have to deal with that. And the association should send them to a collection agency or to a law firm or to some solution if these people will not respond to a courtesy letter. Doug, how do you feel about that?
Yeah, no, I think I agree. Nothing's changed in that regard. I mentioned before that, your policy, your collection policy should specify that each case is going to be decided on its own merits for payment plan requests, waiver requests. Well, that's a factor that can, that's one of those merits that can come into play. If somebody has been historically delinquent, on again, off again in terms of, their account status being current, that may role in the board, how far the board's going to be willing to go to work with them on a payment plan or something like that. So, I think
again, this kind of comes down to the documentation of that it was COVID related, and this was pre-existing to the crisis.
Yeah, pre-existing delinquencies don't affect delinquencies post-COVID. Yeah. I'm sorry if you were not paying. This is not your get out of jail card free.
I've got another question here from Sarah McNeil. She's a CMCA at McNeil Property Management. Do HOA boards and managing agents need to follow the HOA's collection policy, i.e. reminder notice, demand letter, fines, and interest for late payments, or can they waive all or part of the policy for a certain time period? And if they do decide to temporarily waive all of part of the policy, does it need to be a recorded action?
Okay, I'm going to start this answer and let Doug finish it because, when you're a community association manager, a lot of people say to me, is this legal? And I say, rephrase the question because I cannot give a legal opinion. I can give an opinion based on what I said. What was the question?
Go ahead, Doug.
Well, what I've seen some associations actually adopt a short-term collection policy that's somewhat different than their usual collection policy. Again, though, you have these sort of thresholds timing-wise and procedure-wise that are built into your governing documents. You still have to comply with those. But sometimes what you see is like in a typical collection policy is, for example, if the governing documents say that at 60 days, or the earliest you can do something is at 30 days or at 60 days. And maybe in the collection policy, you've put that out a little bit further for administrative reasons to make it more realistic. Well, you can certainly tighten things up from a time frame perspective, but I don't think you can go below what your documents require.
And also the second part of this was, does it need to be a recorded action?
Okay. Let me get back. I had a senior moment there. You have to forgive me. It depends. First of all, it all depends on where your collection policy is in your governing documents. If it's in the Articles of Incorporation, the declaration of the community, or in the bylaws, that's your collection policy. You cannot change that. But your collection policy should be in your rules and regulations that don't require a supermajority, and this is in most governing documents I've seen. So I believe that the board can change on their own their collection policy to adjust to any situation if it's in the rules and regulations, not in the articles, not in the bylaws, and not in the declaration. So yes, you can change it, you can adapt it if it's in your rules and regulations, but if it's hard-coded in those other places, I'm afraid you're stuck with that.
And then if you're going to temporarily change it, does that need to be recorded action?
Doug, answer that one.
Yeah, if you adopt a new rule, absolutely, that should be formally adopted by the board, made in some way, published in some way, made available to the ownership, to the membership.
Recorded in the meeting minutes.
Absolutely.
Oh, it should absolutely be in the meeting minutes. If she means, does it need to be recorded with the county, like, or the courts? Rules are, a lot of rules and regulations are not recorded.
Although
they should be.
There are some jurisdictions that do require even those policies to be recorded, deposited in the county courthouse. So if that's required where you live, then yeah. You would,
all right, I've got we've got a couple more questions, and then we're going to wrap up.
Okay.
So this is an interesting one that is going to get a reaction. Does notice of intent to publish a list of delinquencies provide an incentive to pay assessments? Are there any legal prohibitions to publish a list of delinquent owners?
I got that one. Okay. Number one.
Yeah.
This is what I call a list of shame. Now, everybody in most condos and most HOAs are entitled, the membership is entitled to know who is delinquent or what units are delinquent, because you're allowed to see all the financials. Okay? So let's be clear about that the ownership, the members can see it. They can know who's delinquent, who's not delinquent, or what units or what the aging is. That's part of the financials. That's your right as a member of the corporation or the association to see. But publishing a list of shame and putting it in a public space, here's the danger. If only people who live in the condominium and HOA see it, that might not be a problem. But if my mother comes to my house and she looks and she sees that somebody is not paying, that's a very heavy violation of the Fair Debt Collection Practices Act. That is a lawsuit waiting to happen. And on top of it being wrong, illegal, it's counterproductive, it creates animosity, it creates hostility, it's a foolish thing to do, it's an emotional thing to do, and that's not the way to run a business. And that's my story, and I'm sticking to it.
All right, Doug, anything to add to that?
I agree. It's a terrible practice to do, even if your documents permit it, even if the law permits it where you live. I am regularly telling clients, do not do it, even if you can do it. It just opens you up to so many different potential lawsuits and problems.
All right. I'm just getting into some mechanics on payment plans. Are you suggesting communicating to all owners that you're offering payment plans? If not, is it unfair to owners who are able to pay? And then also, how do you handle payment arrangements for payment plans?
Well, the first thing is, if somebody wants a payment plan who can afford it, what can I say about a person like that who could afford it? I don't even want to comment on that, because that's very disturbing. But a payment plan should be for a certain amount of time, a reasonable amount of time, and it should contemplate all future assessments that will be charged during the course of the payment plan paying period. So that at the end of 6 months or 12 months or 9 months, whatever your payment plan is, the ledger is at zero. And it should be in writing, but you've got to be careful. There are some associations who'll do something they think is clever, that they'll give you a payment plan, and they'll say in the payment plan that if you fall off the payment plan, you divest yourself of any rights, of certain rights to defend yourself in court or something like that. And that should not happen. But a payment plan should be signed. It should be for a specific time period, and it should have a beginning. It should have an end, and the end should be zero balance. That's how we handle payment plans at my company. Doug?
Yeah, I think the message board to its membership should be that if you need one, come talk to us, and we'll try to work something out. I don't think the message should be, if you ask for it, you'll get one. because then you run the risk of being taken advantage of. At the end of the day, if somebody wants a payment plan, there really should be something as part of that request that's showing an economic hardship that's caused them to ask for the payment. And if they can't show that, there may very well be a good reason for the board to say, no, we're not willing to do that in your case. So, again, you don't want to be taken advantage of. I think your messaging to the community is important, that, if you ask for it, well, we're going to consider it and talk about it with you. But that doesn't necessarily mean that everybody's going to get one.
So this is also another sub question of this. What about the issue of not treating all owners, members equally? Example, forgiving late fees, et cetera, for only those that ask.
That's selective enforcement. Is, condos and HOAs are creatures of statute. And there's lawyers always flying around condos and HOAs. You can't have a condo and HOA exist without an attorney. If you start treating some people one way and another people the other way, that's a civil rights violation. Somebody's going to say, you gave the guy with blue eyes a payment plan and I got brown eyes and you didn't give me a payment plan, or you didn't waive something off for me. Selective enforcement is playing with fire. It's playing with nitroglycerin, and I do not recommend it. And I suggest that you endeavor and work hard not to be selectively enforcing rules and regulations.
Yeah, you certainly don't want to engage in selective enforcement. But at the same time, if there's particular facts that warrant a response to owner A of one response and a response to owner B of a different response, based on the particular facts or merits of what they're asking for and what's going on in their situations, you can certainly have different outcomes. But what you don't want to find is that you had two people with the same fact pattern or very close to it, and you treated one differently than the other.
Exactly. That's all I'm saying. I'm not saying that you can't take individuals' needs into consideration, but if you start doing things on a blanket level and say, you just got to be really careful. You got to walk. This is a minefield, and you really have to walk through this minefield very carefully. Be careful out there, folks. It's dangerous, and we live in a litigious country.
So we've gone over, and there were a lot of great questions. I think we covered a lot of ground here. And I want to thank Douglas and Mitch for sharing their expertise and insight with us. If the audience wanted to follow up with either of you, what is the best way to contact you? Mitch?
My email is mitch@axela-tech.com. You could take my name there and Google it. I write so many articles that if you take my name and you Google it, you'll have 20 pages, and you'll be able to find me. I'm head of business development. That means I'm a salesman. I'm not hard to find. So I'll be glad to answer anybody's questions at any time. I'm not hard to find at all. Axela, Mitchell Drimmer, Google me, you'll get to me.
All right. Douglas?
So there's a lot of information, first of all, on our firm's website, which is www.reesbroome.com, including newsletters that we publish there. So that's a good go-to resource if you need it. If you had a question for me specifically, my email address is dlevy, L-E-V-Y, @reesbroome.com. And anybody's welcome to email me if they need to.
Great. And to learn more about Community Financials or to email me a question, you can go to our website, communityfinancials.com, and on the Contact Us page of the website, it'll just come right to me. I want to thank you all for attending. If you have any questions or any way we can be of service for you, please don't hesitate to ask any one of the three of us. Thanks again, and goodbye.
Right. I'd like to say goodbye. Thanks a lot. And I just have one message to everybody. This will be over. Do not despair. It'll be all right. Okay. Thank you and goodbye.
Thanks.
Stay well and safe.
Thanks.